With the recent nullification flurry over Obamacare, gun control, and drug laws, states' rights have become a hot issue once again. There has been much historical debate over the balance of power between the state and federal governments, with the general consensus being that the federal government has preference over the state governments, according to the Supremacy Clause, Article 6, Clause 2 of the Constitution. This clause states, "This Constitution, and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding." This seems rather succinct at first, but notice that the federal laws are only subject to this clause when in pursuance of the Constitution. So, who gets to determine what is pursuant to the Constitution? Well, the Supreme Court ruled in Abelman v. Booth that the Supreme Court gets the final say in matters of constitutionality. Let's get this straight. The Supreme Court ruled that the Supreme Court has the only power to judge the constitutionality of both state and federal laws. They cite Article 3, Section 2, Clauses 1 and 2 of the Constitution as their defense, which states, "The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, the treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof, and foreign states, citizens or subjects, in all cases affecting ambassadors, other public ministers, and consuls, and to those in which a state shall be a party, the Supreme Court shall have original jurisdiction. To all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make." There are two types of jurisdictions allocated to the Supreme Court, original and appellate. Original jurisdiction means that the case goes to the Supreme Court first. These cases are ones involving public officials and states, like if a person sued an ambassador or a state government. Appellate jurisdiction means that one party in the case can appeal the case from the circuit court to the Supreme Court. This means that the Supreme Court can overturn a ruling from a lesser court, such as a state court. Abelman v. Booth is an example of this, in which the Supreme Court ruled that the Supreme Court of Wisconsin couldn't nullify federal rulings on the odious Fugitive Slave Act. So, we can see that the Supreme Court has precedence over the state courts. However, this isn't the end of the story. Nullification is a process where a state legislature declares null and void a federal law. Examples include the Kentucky and Virginia resolutions authored by future presidents Thomas Jefferson and James Madison, respectively, in response to the Libel and Sedition Acts passed by John Quincy Adams. A more modern application would be Missouri's Second Amendment Preservation Act, the Kansas Second Amendment Protection Act, or Colorado's Amendment 64. These are instances in which not a state court, but either a state legislature or a popular vote were used to overturn federal laws within a sovereign state. The 10th Amendment states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." Section 1 of Article 3 of the Constitution provides for the establishment of the Supreme Court, saying, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office." Let's place some emphasis on that first part, the judicial power of the United States. Remember, Section 2 states, "The judicial power shall extend to all cases." So, the power of the Supreme Court is restricted to cases, not the decisions of state legislatures. Since the power of nullification is not forbidden to the states in the Constitution, it is therefore reserved to the states. Section 2 never delegates the power of the Supreme Court to controversies between federal and state laws. The only delegation the Supreme Court received in this part was from the Supreme Court. The Constitution doesn't delegate the Supreme Court the power to empower itself, so this action is therefore unconstitutional. When a sovereign state decides that a law is inconsistent with its constitutional values, the Supreme Court is the one with no right to interfere.